So there we go. All right. So you will receive your final exam today at 1 p.m. It's already uploaded. So it'll maybe after the study session, I'll just go in and open it up so that you can see it, right? I thought what we would do is why don't we go ahead and take a look at the exam questions, okay? And go over them. And then we can also sort of talk about the expectations for the exam. So why don't we start with expectations for the exam first? And I'm going to go ahead and share my screen here. All right. Let me get to our course. Okay. So when you look, I mean, I think you guys all know this, but well, it doesn't hurt to go over it. But if you look on our Canvas site, all right, you scroll down all the way to the bottom. And just like there was for the midterm exam, you've got the final exam information and study session. And then at 1 o'clock today, the final exam questions will be available for you. So we'll just click on the final exam information session. And, you know, the expectations for the exam are, you know, very similar to the expectations for the midterm exam. This final exam is worth a little bit more than 15% of your grade. It covers all the topics that we have covered since the midterm exam, so topics 7 through 12. And then that, you know, for the length of the exam, it's about 2 pages of a double-spaced answer for each of the questions. That's just kind of a ballpark, right? If it's less than that, that's okay. If it's more than that, it's okay. So, you know, if you're a lot more than 8 pages, you might want to go back and edit. If you're a lot less, you know, you'll want to like sort of think about that. But really for me, the bottom line is are you answering the prompts and are you using course material in order to support the points that you're making? Okay. So I mean, you know, as long as you are doing that, you know, that's how I evaluate the exams. I want you to demonstrate competency for what we've learned this semester. And I want you to think critically about the questions. And then I want you to use course material to support your answers. Keep in mind that the best answers are going to use a variety of course materials. You're not going to just depend all on the lectures or all on the textbook or any of the supplementary reading that we've done. You know, you'll want to pull from different sources, right? So some reference to the lectures, some reference to the textbook, some reference to the cases. And you could definitely reference the any material from the most dangerous branch that you might find would be useful. Okay, so keep that in mind. And then also just, you know, you want to make sure you're proofreading, that your material that you're writing is clear and easy to follow. And then I give examples there of the how you should cite. Okay. And there's really no need to use external resources, right? So, I mean, we're really just looking at the course materials that you should be using for the answering your questions. Okay. All right. So before we go on and take a look at the actual questions for the exam, do you guys have any questions about my expectations? All right, cool. So let's go ahead and take a look at the exam questions then. So let me pull this up. So are you guys still able to see my screen? Are we good? Okay. And let me enlarge it a little bit so you can see it. Okay, so your exam is due on Monday at 11:59 p.m. Okay, just FYI. So one of the differences with this exam compared to the midterm exam is that there's one question that everybody has to answer. Okay. And so why don't we go ahead and take a look at that one first? Okay. And so you've got 5 questions here. Okay. We'll look at those in a second. But everybody has to answer this question, question number 6. Okay. And I've tried to make it sort of like a, I don't know, like a, not really cumulative exactly, but I kind of want you to think about everything you've learned this semester. And that's why I put this question on here, okay? And so the question is pretty straightforward and pretty open-ended. So, I mean, it really gives you an opportunity to really sort of show what you've learned. And so the question is I describe what you consider to be the 3 most important things you learned this semester about civil liberties and or the Supreme Court. I would say the best answers would like maybe do both, like, you know, I guess you could have all 3 from civil liberties. If it's all 3 from the Supreme Court, you might want to rethink that, unless you could make a really good case. I would like you to talk a little bit about civil liberties as well. So, you know, describe what you consider to be the 3 most important things you learned this semester about civil liberties. Make sure to provide well-developed description of the things you find most important, as well as an explanation of why it's important to you. And then how will the things you learn this semester impact your life moving forward? You could think about this in terms of how it might impact you personally, politically, as a person living in a democratic society, or in some other capacity too, or otherwise, okay? So I showed that question to my husband last night and I was like, what do you think? And he's like, I said, if you were a student, would you want to answer that? And he was like, it's really open-ended. It makes me nervous. And I was like, yeah, but that's what's so great about it, right? And he asked, is there a right or wrong answer? And I said, there's not a right or wrong answer, right? I mean, how I'm gonna evaluate this is the case you make for what you think is most important, right? And so it's how well, I mean, are you accurately sort of describing the important thing? But really, most importantly, like, why is it important? And like, why it, and of the things you've learned this semester moving forward, like, how is it going to impact your life? And so the detail that you go into in terms of describing that, okay? So that's the question. Everybody has to answer that. And you can pull in material through the whole semester. Like, it doesn't need to be just this second half stuff. It could be anything you've learned the entire semester, okay? And it can be discussions that we had, you know, reading from The Most Dangerous Branch, etc. So do you guys have any questions about that question? All right, cool. Hearing none. Let's go take a look at the content questions, the more specific content questions. Now, I've been really deliberate in the terms of the kinds of questions I'm asking for this. I wanted to make sure we didn't double over the work that you've done in your discussions and the work that you did in The Most Dangerous Branch. So you'll note there is not a question on this about the right to privacy, because I feel like that was really well covered in our discussion with the hypothetical case, and also in the Most Dangerous Branch, the second paper you guys just wrote. There's also not a question about Heller, okay? The right to bear arms, okay? Because I feel like we covered that pretty good in class. So the first question has to do with hate speech, okay? We sort of touched on that in one of the discussions, but only briefly, okay? And there was a whole lecture that was dedicated to it, and obviously there's cases on it. So the question is, according to the court, hate speech receives First Amendment protections, but fighting words do not. Describe the reason the court extends First Amendment protections to hate speech, but not to fighting words, making sure to reference relevant cases. And then the critical thinking question, and again, as I always tell my students, don't throw away that question. I mean, the difference between A answers and non-A answers are how well you do on that critical thinking prompt. And the critical thinking prompt for this one is, do you think hate speech deserves First Amendment protections? Explain your answer, okay? All right. Any questions for that question? Pretty straightforward. The second question is it has to do with the right to press, the freedom of press. And so the question is, despite the fact that the First Amendment reads, Congress shall make no law abridging the freedom of the press, The Supreme Court has recognized the need to limit the press in certain instances. Explain the court's willingness to place restrictions on the press and under what circumstances what such restrictions are warranted. Also discuss the distinctions made by the court between the different types of media. Is the court more or less willing to restrict the First Amendment rights of radio, TV, or print journalism? How has the court dealt with the issue of prior restraint? In what circumstances is prior restraint allowed? Okay. And that last question is really kind of an overlap on the recognizing needs to abridge the freedom of the press. Okay. So that's the second question. You guys have any questions about that?
How many did you say we have to choose again?
Out of this section, 3.
Okay.
Yeah, 3. And here you can talk about student press rights. Okay. I mean, I would actually kind of expect that, right? Because when you're thinking about the kinds of restraints that the court allows on press, as we know from the Hazelwood case, the court's okay with censoring or prior restraining a student press. Okay, so you don't have to, you can include student press in your answer as well. I would sort of expect that. Okay, so that's kind of hint. Okay, question 3 has to do with the Fourth Amendment. And so the Supreme Court stated that reasonableness is the ultimate touchstone of the Fourth Amendment. Okay, and so when you look at the Fourth Amendment is telling you that a person should be free from unreasonable search and seizure. It doesn't say that you have to have a warrant to search. It's saying that you cannot be subject to an unreasonable search. And so, and that's reflected in like Roberts and Rehnquist and others who have said, when we're trying to determine whether or not a search is constitutional, we're looking at reasonableness, okay? So in this, I want, in your answer, explain what that quote means. And here's just some guiding points to consider. How has reasonableness guided the court when it comes to deciding whether a search or seizure is legal, constitutional? What role does reasonableness play in defining what constitutes a search? What role does reasonableness play in getting a warrant or searching without a warrant? And remember, you can search without a warrant. Just because you don't have a warrant doesn't mean it's an unreasonable search. There are exceptions to the need for a warrant. We talked about that in class. And and then finally, of the cases discussed in the textbook, where do you disagree with the court's opinion when it comes to what constitutes a reasonable search or a reasonable or unreasonable search, and explain this disagreement? So I want you to sort of take one case where you were like, no effing way, like you really disagreed with the court when it came to that they said this was a reasonable search or an unreasonable search, right? Maybe that dog sniffing case, you were like, no way, they should let dogs sniff at the front of your door. That's totally reasonable, even though the court said it was unreasonable, right? Maybe, the GPS case or whatever, right? It's up to you to choose. So that's the Fourth Amendment question. You guys have any questions? That's a long ass question, sorry. Do you have any questions about that? All right, and so let's look at 4 and 5. 4 is about the right to counsel, and 5 is about the Eighth Amendment. And so, there was a whole lecture on the right to counsel. What is the right to counsel? In your opinion, is the right to counsel essential to a fair trial? Explain that answer. Can you receive a fair trial without the right to counsel? Explain. I mean, keep in mind, it wasn't until the mid-1960s where the Supreme Court said that a right to counsel for everybody was essential to a fair trial. And so maybe you agree with that with the court. Maybe there are certain kinds of cases that you don't think the right to counsel is essential. But if you do think it's essential, explain why. How has the right to counsel evolved over time? At what stages are the criminally accused entitled to counsel? And do you agree with the court's reasoning regarding the stages at which counsel should be provided? Why or why not? And then the critical thinking question is, should counsel be provided to individuals over their expressed wish to represent themselves? Your textbook talks about that you can waive your right to counsel, right? You can say, well, I don't need counsel. I want to represent myself in this trial. Well, usually that's a bad idea. But hey, it's your rights. But do you think that the court should be more aggressive about that? Do you think that the state should provide counsel even if people refuse it? And then the best answers will discuss key court cases that deal with the right to counsel. Okay. Any questions about that question? And then finally, explain the court's approach to the Eighth Amendment. Points to consider: how does the court determine whether a punishment is cruel and unusual? And keep in mind that cruel and unusual punishment isn't just to the death penalty. The court talks about proportionality, that the punishment needs to fit the crime. And so if you steal, like if you shoplift and the punishment is cut off your hand, that's cruel and unusual punishment, right? Because it's not proportional, okay? So keep that in mind. It's not just about the death penalty. And then, does the court find the death penalty to be a cruel and unusual punishment? It kind of did at one point, so make sure you want to bring that in. And why did the Supreme Court strike down Georgia's death penalty in Furman, but uphold it in Gregg only 3 years later? Do you agree with the holding of court in Gregg? How about in Atkins? Explain and develop. Okay. So there's your death penalty, or your Eighth Amendment case. Any questions about that? All right. Excellent. Now those will appear to you in, at 1 o'clock. So, or maybe, even before that. I'm going to stop sharing my screen and bring us back together. Okay. So now I'm going to open it up to just questions that you might want to go over, right? Not about the questions for the exam, but are there any concepts as you're preparing for this last exam that you'd like to talk about? It's a lot of material. So, I mean, it could very well be that like, as you're working on your exam, you might be like, you might want to drop me an email and like clarify, but if there's anything you'd like to go over, that'd be cool.
I would like to go over something if that's okay.
Yeah, sure.
So when I was reading the textbook, I was a little confused about like where exactly people do have the right to counsel. Like, I feel like that was just kind of muddled in. So I was wondering if you could explain that and like what cases they don't, and like what parts of the process they do.
Oh, okay. So you're not asking where is it in the Constitution, right? I mean, you get that it's at that they're afforded the right to assistance of counsel in the Sixth Amendment, right?
Yeah.
Yeah. But you're sort of wondering like what the court has said over time in terms of what types of cases get right to counsel.
Yeah, and like also like appeals and like obligatory appeals and discretionary appeals. Those were just like those words just blew over my brain and I couldn't
Got it.
figure those out.
Right. So the right to counsel starts at the moment that the individual is being questioned as a suspect. Okay. So, there are some times at the beginning of the process that police might start questioning you, but not because they think you are a suspect in the case, but that they're just trying to get information, right? So like, for example, if cops come to my house, let's say there's some sort of event outside, like an altercation, and cops start asking me like, hey, when did you hear like we've come to investigate like a gunshot or something. And they could ask me like, when did you hear that gunshot? Right? About what time? Who did you see on the street at that time? Like, I can't say, right to counsel, right? Because they're just asking me general questions. Like, I'm not like, they don't think I'm a suspect, right? But then as they're sort of investigating, if they see like in my back pocket, I've got a gun, right? And I start acting all shifty and shit, if I'm like, well, I don't know, why are you asking me, right? And then it's clear that they're starting to ask me like, well, where were you at 1 a.m., right? Or like, what are you doing with that gun? At that point, the right to counsel kicks in, right? So once you're actually starting to be a suspect in the case, you don't need to be charged. A lot of times cops bring you down and just ask you questions before you're charged, right? In the booking process, right? But once you are starting to be questioned as a suspect, once you become a suspect in the case, that's when your right to counsel begins. And that's when they've got to read you your Miranda rights, right? Once you become a suspect in the case. Prior to that, no right to counsel. So that's where it starts. Oh, where it ends is after everybody has a right to appeal unless they waive their right. But everyone has a right of one appeal. Okay. So if you you have the right to counsel as you are plea bargaining, right? So as you start, most people don't go to trial. So when you're participating in a plea bargaining agreement with your defense attorney or with the prosecutor, you have a right to counsel during that. You have a right to counsel at your sentencing hearings, right? So as they are sent, you plead guilty and then you're going to get sentenced. You have a right to counsel then. And then in that instance, if you plead guilty, you actually waive your right to appeal. And so you don't get to appeal at that point. So your right to counsel sort of ends after you get your sentence. Now, it could be that if you are released on probation and on parole, and your parole is revoked, you have a right to counsel at that point, right? But people who plead guilty, they waive their right to appeal. But for those people who don't waive their right and they go to trial and they're convicted, everybody gets one appeal. Okay, so they get to take it to the appellate court, and they basically say there was an error at the trial court. My client was convicted, but they shouldn't have been convicted, and here's why. They didn't have effective counsel. Evidence was submitted that shouldn't have been submitted, that was inadmissible. The jury was biased, whatever. And you'll see if you're following the Derek Chauvin case, like he's been sentenced, right? Or he hasn't been sentenced yet, but that's the guy who was convicted of murdering George Floyd. You could already see that his defense attorney is preparing for appeal, right? Even though he's probably not going to win that appeal, everybody has a right to appeal, and you have a right to counsel through that first appeal. Now, let's say you appeal a case and you have right to counsel and you don't like the outcome at the appellate court. You want to take it to the next level, right? You might appeal at the circuit court level, or you might appeal at the state Supreme Court level, and you want another appeal, right? You want another higher court to hear that case. At that point, you don't have the right to counsel because it's discretionary. That you have a right to one appeal, but you don't have a right for a future appeal, okay? The court gets to decide whether or not they're going to review your case on future appeal. And so you lose your right to counsel, or let me rephrase that. You can still bring counsel, but you just got to pay for it, right? You have to pay for it, or somebody has to do your pro bono work. But that there's not a constitutional mandate that you get counsel after your first appeal. Jagriti, does that help?
Yeah, that really does help.
Cool.
And then, sorry, just to like follow up on that. So your right to counsel doesn't exist for Supreme Court cases either, like the main Supreme Court cases?
Yeah, right. So I mean, in a way, I mean, the Supreme Court is sort of different because, right, well, but bottom line is you don't have a right to counsel. Somebody has to pick your case up, right, to represent you.
Mm-hmm.
In a way, that's, by the time a case gets to the Supreme Court, there's so much investment in the outcome of that case that it's not like poor people have to like scrounge about, like the indigent have to scrounge about to get assistance of counsel, because like with the Gideon case, the Clarence Gideon, remember, like he didn't have counsel at his trial, but he also didn't have counsel at the Supreme Court. But then Abe Ford has stepped up and he's like, I'd love to defend you. I'd love to represent you at the Supreme Court because the stakes were so high. So by the time you get to the Supreme Court, right, if you don't have counsel, the chances that the Supreme Court would even hear that case would be slim to none, right? I guess you could be a really excellent person. I mean, in a lot of cases that go to the Supreme Court are not like criminal cases, but uh let me use like a death penalty case. Like a lot of times, and not to get too much into the weeds, but if an individual like exhausts their appeals for the death penalty, there's actually outside parties that can pick up that appeal on their own. It's called a writ of habeas corpus. And so it's like, if you're a death penalty, if you've been sentenced to the death penalty and then you like get an appeal and your appeal is denied, your right to counsel, that the defendant's right to counsel ends at that point. But actually you can have like a third party that like is saying, like in the name of justice, they say they want, or they file a writ of habeas corpus on not actually representing that individual, but just basically saying like due process has been violated. And as a third party, I want the courts to investigate whether or not due process has been violated. And so again, you'll have an attorney who will do that, but they're really just sort of like, they're not necessarily doing it for a client. They're kind of doing it for the greater good, right?
Okay.
So just because you can't get counsel doesn't mean you can't find relief, or just because you don't have a constitutional right to counsel doesn't mean you can't get some relief. But you're going to get that relief in a different way. And an attorney is not going to pick up that case if they don't feel like that it should be picked up and reviewed by the higher courts.
Okay.
Sorry if
Thank
that got a
you.
little
was really helpful.
Oh, okay, cool.
Is that what happens when like a celebrity, okay, I don't know like who it was, but like there was a celebrity maybe last year that was like really for getting someone off of death row. They were like, you have to like relook at this case, and then it like got him off of it. Like he no longer was sentenced to death. And is that what happened? Like some third party like would pick it up?
Yeah. So, and I don't know if that was the Kim Kardashian. I mean, I know Kim Kardashian and Kanye West have been sort of involved in these high profile cases, although it's, but right. A lot of times high profile law firms will pick up cases on what's known as pro bono. They provide defense counsel for free because they are because since your right to appeal ends after the first appeal for indigent folks, right? Then high profile law firms like Alan Dershowitz, say what you will about Alan Dershowitz. I mean, he's kind of lost a lot of credibility recently. But his law firm historically as they represent really rich people. And then they use the money that they get from representing rich people to do pro bono work for indigent clients that have exhausted their constitutional mandate for defense. And so, law firms will do that for free through the pro bono work. If you're a celebrity, you could spend your money in order to hire an attorney for somebody who you feel like has been wronged. And so I don't know the details of the case, but right, the Kardashians have a lot of money. In fact, their dad's a lawyer. He represented O.J. Simpson, right? And so I'm sure they use their own money, and you can always use your own money or somebody else's money to get the defense that you want.
Okay.
It kind of screws out though. Excuse my language. It kind of really sells short indigent people who get the one appeal, but then don't have like either wealthy benefactors like celebrities, or if a law firm doesn't feel that their case is worthy of picking.
Yeah, I was gonna say like if you have money, you could just like keep doing it.
Yep.
Over and over. So.
Right. And to think like that up until 1965, like there wasn't a mandate for like even counsel at a criminal trial, right? For those who didn't face a capital offense. So we've come a long way in terms of the right to counsel, but that doesn't mean that, I mean, the long arc of justice is, or the arc of justice is long, and, or what is that? The arc of history is long and advanced towards justice, right? Well, we're still not there. We never will be, right? So, but that's why you guys need to go to law school. Become public defenders. Any other questions? Brandon, you got a question?
Oh, no, I just kind of came here just to kind of hear what's going on, and in case somebody else brought something up,
Cool.
so I could just kind of take note of it too.
Sophia, do you have any questions?
No, she actually asked the question I had about like just in general about, I think I missed that like quiz actually, but that's all right. So no, that was all. That's good.
The right to counsel?
Yeah.
Yeah, okay. Right. And there's a whole lecture on the right to counsel that is semi-helpful, but it kind of provides an overview, but then more of the details are in the text. All right, well, excellent. So I look forward to reading your exams. You guys have done a great job this semester. This was in retrospect, I mean, I probably gave you guys too much work, so I'm glad you guys stepped up to the plate. I'll probably review that upon if I teach this again in an asynchronous format, but good luck. I look forward to reading your work, and grades will be posted, probably midweek next week, depending on how things go. Okay. I'm available if you have questions as you're working, so don't hesitate to either call me or drop me a text. Okay. All right. Talk to you guys later.
Thank you.
You're welcome.
Bye.
Bye-bye.